is Your Health, a podcast of the Integrated Health and Social Services University Network for West Central Montreal.
Hello and welcome to Your Health. I'm Barry Morgan. We hear a lot about personal data and confidentiality in the news, but the concept of confidentiality does not only apply to, for instance, the banking world, people's personal finances. This principle also exists in the field of health and social services. Well, to explain what confidentiality really is, we welcome Angelique Sassis, a complaints officer at the Office of the Commissioner of Complaints and Quality of Services for CIUS West Central Montreal. First of all, thank you very much for being here.
You're very welcome, Mr. Morgan.
So what exactly is confidentiality? It may sound like an obvious, people would know, but your definition.
Yes, it's the right of the user to expect that all the contents of his medical file not be disclosed to anyone else without his permission or without his consent. We know that a lot of employees in the institution, in the health institution, have access to all kinds of information with respect to the medical file of a user. But we should not forget that this is only for the purpose of executing the job that they have to do. This obligation is also incumbent upon the volunteers, and we know we have a good culture of volunteers at our institution, and it also extends to digital and manuscript form of a medical file.
What does Quebec law actually say about confidentiality?
Yes, there are, the legal framework is quite extensive, so I'm just going to refer to Section 19 of the Health Act, and I'm just going to read it.
Sure.
The record of a user is confidential, and no person may have access to it except with the consent of the user or the person qualified to give consent on his behalf. Information contained in a user's record may, however, be communicated without the user's consent. Now, they're dealing with this particular phrase has been drafted in order to take account of the multiple exceptions to the rule. As we know, when we have a rule, we have exceptions.
So there are distinctions between the definition of confidentiality and the Quebec law?
The definition of confidentiality is conveyed in Section 19 of the Health Act. The Health Act explains that the user's file, the medical file, and the contents of that file cannot be disclosed to anyone without the user's consent. So we have that particular article, that section, which is the primary section, and we refer to that, and of course there are exceptions to the rule.
And maybe we'll get to that in just a moment.
Yes.
But I was also curious to know, professional secrecy, is that the same thing, or is it perhaps complementary? Yes,
I would say it's complementary because it's defined as the obligation imposed upon a professional to maintain confidential all the information that he has obtained within the relationship of the user. When, for example, when the user sees a professional, and we'll name the doctor or a dentist or a pharmacist, and confidential information is conveyed within that relationship, well, that has to remain confidential.
Why is it really so important to maintain this kind of user confidentiality in the first place?
It's very important to maintain it. I just wanted to add, Mr. Morgan, I just wanted to add something else concerning the professional secrecy,
Sure.
Which is important. When we talk about professional secrecy, we're dealing with all the professionals, and of course we're talking about a healthcare institution here, so we're talking about the healthcare professionals such as the doctors, the dentists, the nurses, the psychologists, the social workers. They are bound by an obligation of confidentiality as an employee of the institution, but they're also bound by this secrecy, this professional secrecy. So any information, any confidence that the user has given within that context is guaranteed as well.
Okay. Why is it so important to maintain user confidentiality in the first place, Ms. Sassis?
It's very important because user confidentiality is a fundamental right. It's a fundamental right that's guaranteed by our charter. It's a fundamental right that's guaranteed by the Civil Code of Quebec. And it touches upon the respect of the dignity and the freedom of the individual. As a fundamental right, it is extremely important that we follow all the necessary law and provisions that are applicable in order to avoid violation of this particular obligation.
It's so much about just respecting the rights of the individual and their privacy, and to make sure that whatever information that they have isn't disseminated somewhere and
Absolutely.
just doesn't end up somewhere in the public domain.
Absolutely. And if we refer to Section 3 of our Civil Code, which states, and I quote, "Every person is the holder of personal rights, such as the right to life, the right to the respect of his name, reputation, and privacy." So there we go. We have privacy. And again, Section 5 of our Charter of Human Rights and Freedoms also states that every person has a right to respect for his private life. So there we go. We have them. They're embedded in these laws, which are fundamental laws.
Understood. And who in our organization must absolutely ensure user confidentiality?
Yes, it's the institution. And when we say institution, we mean all of the employees that are bound by this obligation of confidentiality. We saw before that the professional employees are also bound by the professional secrecy. The non-professional employees, of course, are bound by the obligation of confidentiality. And it's important to understand that this obligation of confidentiality persists even after the employee has left the employ of the healthcare institution.
Okay. In other words, in perpetuity, or in other words, they're never allowed to speak about somebody's private issues even after they've left this. For instance, if they've left the
Yes,
COs?
because we're talking about fundamental rights.
Well,
Absolutely.
that makes sense, doesn't it?
Yes, it does.
Again, if the goal here is to respect somebody's privacy.
Absolutely.
And to maintain their confidentiality. You mentioned this before, exceptions. I should ask, in which cases can a user waive confidentiality?
Yes, absolutely. I've decided to choose an example with respect to consent to care, and I have divided it, of course, up in two sections so you can understand how this personal information is conveyed and in what context it may be conveyed. Mm-hmm. When a user is competent, the user may consent to a member of his family, it's usually done to a member of his family, to have access to all this privileged information in order for that individual to make a decision with respect to care. But it gets a little bit complicated when the user is not competent. What do you do? Who decides? Who has access to this privileged medical information? So the law tells us that under Section 15 of our Civil Code tells us that you have to look and see if there is somebody that holds a curatorship or a tutorship or a mandatory. Now, in the absence of all of these three individuals, then Section 15 of the Civil Code states that the spouse, whether this individual is married or in civil union or even de facto means that this individual is acting as a spouse. The spouse has access to the privileged information, or in the absence of a spouse, we have a close relative, and in the absence of a close relative, any individual that has demonstrated interest in this particular user. Okay. So they are, by the nature of their status, they have the right to obtain personal medical information in order to give clear consent with respect to the care.
Okay. And that's really what it's all about. It should really come down to what's the patient, what he or she would like in terms of care.
Absolutely.
At the end of the day.
Absolutely.
Okay. What happens if we just talked about a case where somebody grants permission, so to speak, to a second or third party, but what happens if a user's privacy is really not respected?
Yes, that could lead to very negative, potentially very negative situations. Sure. Because, like I said before, it compromises the fundamental right of the individual. Oftentimes we see that private documents are lost, or they're not classified in the right place, or they're sent to a different department. When the information contained within those documents are disclosed to third parties that have no right to have to have access to this information.
Mm-hmm.
This could be very potentially harming to the user. There could be damages. There could be a social stigma associated with that information, with the nature of the information, depending on what the information has been disclosed and what type of information. So this is why the legislator and our healthcare institution has provided, for example, the framework in order to respect and to try to abide by by the laws, and of course by the protocol and the confidentiality obligations.
Fortunate to have a system where the system actually does bend over backwards to try to ensure as best as possible somebody's confidentiality and privacy is respected. Yes,
absolutely, Mr. Morgan. Yes.
Okay. Thank you very much for your time.
You're very welcome.
Very eye-opening information. That is Angelique Tsassis, a complaints officer at the Office of the Commissioner of Complaints and Quality of Services for CIUS West Central Montreal. And if you have any questions about confidentiality, well, you can call the office. Here's the phone number, 514-340-8222, extension 24222. That's 514-340-8222, extension 24222. And that's it for this edition of Your Health. Thank you for your time. To hear our previous programs, you can find them at podcast.ciuswestcentral.ca. That's podcast.ciusswestcentral.ca. Let us know if there's a topic you'd like us to explore in the future. I'm Barry Morgan. Until next time.
You've been listening to Your Health, a podcast of the Integrated Health and Social Services University Network for West Central Montreal.